In this section, we are going to look at what is a final hearing and what happens on the day of the hearing. A final hearing is a hearing at which the tribunal determines the claim or such parts as remain outstanding as at the date of the hearing. There may be different final hearings for different issues, for example, liability, remedy, or costs. Final hearings are held in public unless an order under Rules 50, privacy and restricted reporting, are in place where, for example, or national security under Rule 94 has been made. If order under Rule 50 or 94 has been made, then they will not be in public. The parties will be given at least 14 days notice of the date of the final hearing. Sometime, law students and members of press may also attend the hearing since they are public. However, please do note that before the final hearing takes place, just close to the hearing, usually there is an order in place which requires the parties to send certain documentation to the tribunals, and that is the documentation which has been agreed for the hearing purposes, usually between both parties, that is claimant and respondents. The following documentation should have been served to the employment tribunals: the hearing bundle, the witness statements for both parties, any other documents produced to assist the tribunal at the hearing, such as a list of issues, chronology, Scott schedule, or cast list. Any relevant orders, such as a witness order or an order with which the other party has not complied with, will have significant effect on the hearing. Generally, it is the respondent's responsibility to send all the documents in. However, it is the claimant's responsibility to send their witness statements in. Please refer always to the relevant case management orders, which will explain what is required of who. You should check with the respondent if the bundle of documents has been sent to the employment tribunals. Usually, respondents' representatives would copy you in when they send any documents or any correspondence to the employment tribunals or make any application. What happens if you fail to attend the hearing? If one of the parties fail to attend the tribunal for the hearing, either in person or through a representative, Rule 47 provides that the tribunal can dismiss the claim or proceed with the hearing in the absence of that party. Although not specifically an option under Rule 47, the tribunal may also decide to postpone or adjourn the hearing. What will be the order of the events in the main hearing? You will normally be required to be present at the tribunal at around 9:30 a.m. Usual start time at employment tribunals is 10 a.m. At the tribunal building, there will be separate waiting rooms for the claimants and the respondents. You should sit in the claimant's waiting room until the tribunal clerk comes in the room. The clerk will call your name and will have details of your hearing to hand. The clerk will take your name and that of your witness if called. The judge will be notified that the claimant is present at the tribunals. At around 10 a.m., the clerk will come again and will tell you that the judge is ready. You will then be escorted to the relevant tribunal room. Both parties enter the tribunal room together. However, if you feel comfortable, you may keep a small distance. Once all parties are in the tribunal, the clerk will inform the judge. The judge will then come out in the room and all parties should stand. The clerk will normally say out loud, "All rise." Once everyone has settled down and sat down, the judge will discuss a number of matters for housekeeping purposes. For example, whether all the documents and witness statements have been submitted, if there is any application to make or has been made by any of the parties, etc. If it is a straightforward unfair dismissal or arrears of pay claim, only single judge will be sitting. In discrimination claims, there will be a panel of 3, including a legally qualified judge who will also be the chair of the panel. One of the panel members will be from employer-related backgrounds, for example, experienced HR professional or an ex-business manager. The other panel member is generally from employee background, for example, past trade union representative. The judge or the panel will also ask about their views about the reading time, that is, reading documents in the bundle, for example, and how long the parties will take to cross-examine the other party's witnesses. The parties who are legally represented, usually their legal representatives are in a position to inform the judge whether they are going to take 1 hour with certain witness, cross-examination, for example, and half an hour with another witness because of their experience. If you are not represented, you might have prepared a list of questions, and on the basis of that list of questions, you may be able to roughly state how long you might take with the cross-examination. But do not worry if you're unable to state exactly, because this is what the judges expect from claimants who are not legally represented. If you have read the witness statement of the respondent's witnesses, you would know how long you might take to ask all the questions. You can make a list of questions to ask from the respondent's witnesses. Generally, it should not take more than an hour and a half unless the witness statement is lengthy or there are a lot of factual disputes. This also again depends upon how prepared you are. Once these matters are discussed, the judge usually informs the parties that they should be back at the tribunal after lunch. That is, at around 2 p.m. unless the tribunal decides to take early lunch break at 12, in which case the parties should be back in the tribunal at 1 p.m., especially if it is a hearing listed for more than a day. Again, the parties should be present in the relevant waiting room in time, unless, of course, if it's a virtual or video link hearing. But again, they should be back on their laptop, logged in the virtual lobby. The court clerk will come and escort the parties to the tribunal room unless ordered otherwise by the tribunal. During this time, the tribunal would have read all the key documents and the witness statements and will have a good picture of the issues and the evidence of both parties. Next stage is to test the evidence through real live witnesses. So who goes first to give evidence on the day? The party that has the burden of proof will usually call their witnesses first. So for example, in an unfair dismissal claim, the respondent will go first unless there is a dispute over whether the claimant was dismissed. Whereas in a claim of constructive dismissal or discrimination, the claimant will start to give evidence. At the end of the hearing, you will also be required to make your submissions, that is, summarize your case. Let's find out in the next lecture what submissions are and how to make submissions to the Employment Tribunal.